While they take a break, let's bring in Holly Davis, attorney from Austin, Texas. Holly, you and I have been communicated while we've been watching this about how the defendant did on cross-examination by the prosecutor. How would you suggest he came across to this jury?
Unfortunately, I think for his very strong self-defense claim, which is there, but for his testimony, it seems like he's taking about 5 steps back. The way he's taking 5 steps back is disputing facts that aren't even in question, adding a very concerning bit of new information to his claim of self defense, and that is that now he's testifying that he didn't intend for the gun to even go off. As we know, one of the most important parts of his defense is that he had to do what he did to the victim because he felt like his life was threatened. Now he's put into question whether or not he can even claim self-defense if he never intended for the gun to go off. It's all very confusing. At the same time, I think his attorneys could have done a better job, although it's very hard in the middle of trial. I think they could have objected a little bit more to some of the more argumentative moments of that cross-examination, simply so that their client could get a chance to gather himself and go back to some of the core pieces of what they might have rehearsed or discussed in advance of the trial. So a very confusing cross-examination for the defense. I can't imagine the rehabilitation that's going to need to occur. They need to decide whether or not he did shoot this victim because he thought his life was threatened, or if this was just like a fisticuffs gone wrong, Judge. Very shocking.
All right, and I'm going to see, I understand the jury may be coming back in the courtroom. I'm not sure if we can watch that at the same time because I have one other question for you, Holly, and that is, do you think now that you've seen the defendant testify, do you think that the self-defense claim would have been better without his testimony?
No, I think he still needs to tell the jurors what was in his head for state of mind purposes to be acquitted. He needed to do it.